What's up, Missouri weed smokers? While smoking weed may be fun, getting a ticket for it and having to pay a bunch of money to the state is not. Call Combs Waterkotte if you have been pulled over or given a ticket for smoking weed while driving. Funny intro out of the way, let's get on with the audio. Thank you for visiting the Combs Waterkotte website and our Weed, DWI, and DWI Defense Lawyer in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been charged with weed, DWI, and DUI in the state of Missouri, we can help. Don't face the state and court system alone during your weed, DWI, and DUI charge. Contact one of our Missouri Weed, DWI, and DUI defense lawyers today at 314-900-HELP to protect your rights and future. Combs Waterkotte is committed to handling all weed, DWI, and DUI defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our weed, DWI, and DUI defense lawyers in Missouri and setting up a free consultation with our attorneys. Weed, DWI, and DUI defense lawyers in Missouri. Weed, DWI, DUI charges in Missouri are more common than most people think, and you don't have to be high to get arrested. Missouri law allows prosecutors to charge you with a DWI based on alleged marijuana impairment alone. Combs Waterkotte's experienced Missouri marijuana DUI attorneys know how to challenge field sobriety tests, drug recognition expert testimony, and flawed blood or urine testing. If you've been arrested for driving under the influence of weed, our team is here to fight for your freedom and license. What is a weed, DWI, or DUI in Missouri? In Missouri, you can be charged with a DWI, driving while intoxicated, for marijuana if an officer believes you're impaired, even without any alcohol in your system. Unlike alcohol-related DWIs, there's no legal limit for THC. That means it comes down to subjective signs like how you're driving, how you speak, and how you perform on field sobriety tests. You don't have to go through this alone. Contact one of our Missouri Weed, DWI, DUI lawyers today at 314-900-HELP to protect your future. Under Missouri Revised Statutes, Section 577.010, a person commits a DWI if they operate a motor vehicle while in an intoxicated or drugged condition. That includes marijuana, even if you bought, possessed, and consumed the marijuana legally. The law doesn't care how much THC is in your system. It only matters whether the officer thinks you were under the influence, i.e., high, at the time. Important? You can be arrested for a marijuana DWI in Missouri even if you weren't high at the time. If an officer believes your ability to drive was impaired, or if you admit to recent cannabis use, that's often enough for an arrest and charges. Can you get a DUI in Missouri for marijuana use? Yes, you can absolutely be charged with a DUI in Missouri for marijuana, even if you're not visibly high or don't feel impaired. Missouri law focuses on whether your ability to safely operate a vehicle appears impaired due to drugs, and police officers have wide discretion to make that call. Common reasons drivers are arrested for weed, DWI, include admitting recent marijuana use during a traffic stop, failing field sobriety tests, showing signs of confusion, bloodshot eyes, or slow reaction time, being evaluated by a drug recognition expert, DRE, testing positive for THC in blood or urine. Even if you're a valid medical marijuana patient, that won't automatically protect you. There's no legal limit for cannabis, and prosecutors don't have to prove a specific amount of THC, only that you were impaired while driving. How Missouri police detect marijuana DUI. Unlike alcohol, marijuana doesn't show up on a breath test. That means Missouri officers rely on more subjective tools to decide whether a driver is under the influence. If you've been pulled over and suspected of driving high, here's how that process typically unfolds. Field sobriety tests. Officers may ask you to walk a straight line, balance, or follow a pen with your eyes. These tests are based on physical coordination and can be influenced by nerves, injury, or fatigue, not just drugs. Drug recognition experts, DREs. Some departments call in DRE-certified officers who claim to detect impairment based on pupil size, muscle tone, and divided attention tests. Their opinions are often challenged in court. Blood or urine testing. If you're arrested, police may seek a warrant to test for THC, but a positive test doesn't prove you were impaired. Marijuana can stay in your system for days or even weeks. Statements or odor. Admitting recent use or having the smell of cannabis in the vehicle can give police probable cause to arrest or search further. The bottom line, Missouri police don't need a scientific threshold to charge you. All it takes is their judgment, and our job is to challenge every assumption they made along the way. Defenses to marijuana, DWI charges in Missouri. In Missouri, defending against a marijuana-related DWI, driving while intoxicated, charge requires a nuanced and strategic legal approach. Unlike alcohol-related DWIs, which are based on blood alcohol concentration, BAC, marijuana DWI cases often hinge on subjective indicators, officer observations, and questionable testing procedures. Our Missouri weed DWI attorneys use a variety of targeted defenses depending on the facts of your case. 1. Challenging the traffic stop. Unlawful stop. If there was no clear traffic violation or reasonable suspicion, any evidence collected afterward, including sobriety tests or statements, could be suppressed. Profiling or pretextual stops. If you were pulled over without valid cause, the legality of the entire arrest may be in question. 2. Faulty field sobriety tests, FSTs. Unlike alcohol cases, there's no scientifically accepted field test for marijuana intoxication. Many FSTs used in weed DWI stops are non-standardized and highly subjective. Medical conditions, injuries, or anxiety can affect performance and don't prove impairment. 3. Drug recognition. Expert, DRE, flaws. DRE assessments are based on opinion, not hard science. Their conclusions can be challenged in court. We cross-examine DREs on their training, methods, and assumptions, often revealing inconsistencies or bias. 4. Blood or urine testing problems. THC levels don't equal impairment. You can test positive days after use, long after the effects have worn off. We challenge tests based on residual presence, lab errors, or improper collection procedures. 5. No evidence of actual impairment. Marijuana DWI cases require proof you were impaired while driving, not just that THC was in your system. We highlight clear driving behavior, lucid speech, calm demeanor, and coherent responses from the body cam and dash cam videos to undermine the prosecution's theory. 6. Procedural and constitutional violations. Miranda violations, improper searches, or illegal arrests can result in evidence suppression. Our team scrutinizes every step of the police interaction for mistakes. 7. Independent video or witness testimony. Dash cam footage or passenger testimony that contradicts officer claims can tip the balance in your favor. If you're facing weed DWI charges in Missouri, the stakes are high, but so are the opportunities to fight back. At Combs Waterkotte, we use every available tool to challenge the evidence, protect your rights, and work toward the best possible outcome. Read our Ultimate Guide to Marijuana Traffic Stops in Missouri here. Can you refuse a marijuana drug test in Missouri? Under Missouri's implied consent law, if you're lawfully arrested on suspicion of DWI, including for marijuana, you're considered to have consented to chemical testing of your breath, blood, or urine. Refusing the test is legal, but it may come with consequences. What happens if you refuse a drug test? Automatic license revocation. Refusing a blood or urine test results in a 1-year license revocation under Missouri law, separate from any criminal DWI case. However, you have a right to request an administrative hearing within 15 days to challenge the suspension court. Our Missouri Weed DWI DUI lawyers can fight for you to keep your license at the administrative hearing. Admissible in court. Your refusal can be introduced as evidence of guilt at trial. No protection from prosecution. Even without a test, you can still be charged and convicted based on officer observations or other evidence. Should I refuse a drug test for a weed DWI? Our weed DWI DUI lawyers in Missouri always recommend refusing all field and chemical tests until police acquire a warrant. By submitting to the tests, all you're doing is giving the state more evidence to use against you. Give the police as little evidence as possible, and let us do the heavy lifting from there. Can you be forced to give a sample? In most cases, officers must obtain a warrant to draw blood without consent. But under certain conditions, like serious injury or a fatal crash, Missouri law allows for a non-consensual blood draw without a warrant. These cases can be challenged on constitutional grounds. Penalties for a marijuana DWI in Missouri. Getting convicted of a weed DWI in Missouri can lead to both criminal penalties and life-altering consequences. Whether it's your first offense or you've been charged before, here's what you're facing under Missouri law. Criminal penalties. First offense, Class B misdemeanor, up to 6 months in jail and $1,000 in fines. Second offense, Class A misdemeanor, up to 1 year in jail and $2,000 in fines. Third offense, felony DWI, up to 4 years in prison and $10,000 in fines. Probation, mandatory treatment programs, or ignition interlock devices may be ordered. License and life consequences. 30-day license suspension for a first offense. 1-year license revocation for second offense within 5 years. SR 22 insurance requirement and increased premiums. Potential loss of employment, CDL eligibility, or housing opportunities. Why choose Combs Waterkotte for a Missouri weed DWI case? Weed DWI charges are often built on shaky ground, and you need a defense team that knows how to pick it apart. At Combs Waterkotte, we've defended hundreds of clients against marijuana-related DWI accusations in and around Missouri. We understand the unique flaws in these cases, from unreliable testing to questionable traffic stops, and we use that knowledge to push back hard against prosecutors. Our attorneys have over 50 years of experience securing dismissals, favorable plea bargains, and not guilty verdicts in high-stakes DWI cases. What it's like to have Combs Waterkotte on your side in Missouri. From your first call to the final outcome, you'll know you've got someone in your corner who actually gives a damn. We explain your options in plain English, answer your texts and calls, and stay 2 steps ahead of the prosecution. No scare tactics, no hidden fees, just smart, aggressive defense from people who treat you like a human being. Not a headline. Contact a Missouri Weed DWI lawyer today. If you've been arrested for a marijuana-related DWI in Missouri, the clock is already ticking. You don't have to navigate this alone. Call 314-900-HELP or contact Combs Waterkotte online right now to set up a free, confidential consultation. We'll listen to your story, explain your options, and help you take the first step toward putting this behind you.